Good evening. This is the September 17th, 2013 edition of the Austin Constitution Meetup. I'm John Roland. The topic for this evening is cognitive dissonance and the Constitution. What is cognitive dissonance? The term cognitive dissonance was originally coined by social psychologist Leon Fessinger to explain how World War II German prison guards could not only obey their orders to slaughter their prisoners, but come to think that doing so was right. The observation was that when many people are forced to behave contrary to their beliefs and moral values, they will change those beliefs and values rather than change their behaviors. Later, other investigators started using the term in other ways. They studied cases in which the change was in the opposite direction, but the finding that beliefs are more malleable than behaviors has been the more important in this field of research. It came to be recognized that not only were beliefs and values malleable, but also perceptions and understandings. Constraints on behavior can change the way people see and think. The classic treatment of the subject was in Orwell's 1984, in which party boss O'Brien tortured dissident Winston Smith into denying that 2 + 2 = 4, and accepting that it is instead whatever the party says it is. That was also the theme of a Star Trek Next Generation episode in which Captain Picard was tortured by his Cardassian guard to try to get him to deny the evidence of his own eyes. There's a related phenomenon called displacement behavior. Frustrated desires can produce unproductive behaviors to discharge tension. For example, the classic example is a fish that, when frustrated in its efforts to compete with a bigger fish to mate with a female fish, will beat its head against a rock. This head-beating behavior was thought remarkable at the time, and it came to be understood that it was a way for the fish to discharge tension, even though it served no useful purpose. And then other ways of doing that began to become observed in the animal kingdom and in human beings. These unproductive behaviors can nonetheless shape perceptions, understandings, and communications. In other words, by behaving in unproductive ways, they can then often further change the way people and animals perceive things, understand things, and the way they communicate with others. But that can lead to confrontation with reality or with public demands, which returns the tension, in the case of people. That presents an opportunity to redirect the behavior into more productive courses. Lawyers and judges are particularly important in this regard. We see an ongoing example of cognitive dissonance in the ways seemingly honorable users of legal English, when pressured by demands on them to accept clear departures from strict compliance with the Constitution as originally meant and understood, choose not to resist, but rather adjust their beliefs to conform to their actions, and come to sincerely embrace interpretations of the Constitution that seem incredible to competent linguists and historians of law whose positions or careers are not at stake. Part of the problem is a failure to educate. Constitutional education was mixed, but often intense in the era of the one-room schoolhouse, until students became grouped into classes by age in the 1920s. And my grandfather was an example of a school teacher who taught first in one-room schoolhouses from about 1899, made the transition around 1920, and continued teaching in classrooms organized by age group until about 1935. Beginning about 1950, a new generation of educators, inspired by the New Deal, began reshaping public education on American government. The shift was advanced further by the unionization of public school teachers in the 1960s, when they began to be able to shape their own curricula without much concern about being fired for it. Colleges and law schools came to eventually be influenced by this same process. In the 1960s, colleges began abandoning requirements for courses in American government for a degree. You may recall references to liberal education going back to the early part of the 20th and the most of the 19th century and before. At the baccalaureate level, it was understood that a college-educated person should be broadly educated in many fields and not just in a specialized field. But beginning in the 1960s, colleges, under demand from students and their teachers and their parents, began to be treated more and more as trade schools, preparing students for the professions. And law schools, even earlier, began teaching only classes with constitutional issues rather than the Constitution itself. Most lawyers and judges only learn as much law as they need for the cases they take, and they can go through an entire career without a constitutional case. Reliance on precedent is an important factor here. It is easier for judges to rely on precedent than to learn the Constitution. It is easier for lawyers to rely on expectations of how judges will decide than insist on strict constitutional compliance. An adversarial judicial system that emphasizes winning over getting it right constrains lawyers to do what it takes to win and accept wrong precedents if that is what it takes to win. Entrenched doctrines then result. The legal community has become a tribal culture with its own customs, policies, and practices that may be inconsistent with the Constitution. But a legal career is not advanced by bucking established practices, and may be ended by doing so. Lawyers have made themselves indispensable and now own the courts and what happens in them. So what stands in the way? Well, first, of course, is dishonesty. That's always what many laymen first suspect of lawyers, judges, and other public officials. But it's not quite as simple as that. It's also a matter of ignorance. As I said, many lawyers and judges really don't know much about the Constitution or how to decide constitutional cases. There is an element of incompetence. Too many lawyers become judges because they can't make it as lawyers. So the system does not tend to elevate the best lawyers to judicial positions, but the worst ones. There's also a problem with complexity and subtlety. In the early decades of the Republic, the issues were simpler. They didn't have the complexities that we face today, and a lot of factors like, the sciences, which are beyond the ken of most lawyers and judges. There's also a problem with inertia. When there are too many precedents for too long, the prospect of overturning the entire line of precedents by overturning a case decided 200 years ago is just daunting to them. That it's one thing to peel it back, maybe the last precedent a few years ago, but to try to peel it back, 50 years, 100 years or more, is just they're just not prepared to undertake that. There's also a problem with buy-in, and this is where cognitive dissonance comes in. This is where lawyers, judges, and even lay people begin to accept the wrong precedents as though they were right, and to adjust their thinking, their understanding, their values even, to conform to the errors instead of working to correct the errors. And then, of course, finally, there's lack of public demand. Most people do not understand what lawyers and judges do, or understand when they go wrong or what they should be trying to do about it. They usually only get involved in where they have a case in which they're a party. And then they're often totally inadequate to deal with it. And if injustice is done, as it often is, they may spend the rest of their lives dwelling on their own injustice and trying to fix that injustice rather than trying to address the general problem of preventing injustice to other people similarly situated. Leading the herd becomes the issue. If decision makers insist on acting as a herd, reformers must lead the herd in a different direction and against the flow of money. I'm fond of saying that there's plenty of money for violating the Constitution, but precious little for enforcing it. And that's indeed a problem. Money tends to be short-term. Most investors think only to the next quarterly return, or maybe to the next, at most 5 or 10 years. The Constitution is a document that's designed to serve the needs of the people for centuries or millennia. It's not a short-term design, and it is therefore likely and does run up against short-term thinking. Short-term thinking tends to try to violate the Constitution because short-termers don't understand how what they may gain in the short term will ultimately prove disastrous in the long term. If herd speak is constrained, that can influence decisions. So if you can get decision makers, lawyers, judges, other officials, even the public, to speak differently about these issues, that can often begin to change their behaviors. Herd speak can be led by seeking constitutional amendments, even if the amendments are never actually adopted. And for those who have followed my work, I have produced a long list of constitutional amendments. I would hardly expect they would all be adopted, certainly not in my lifetime, but if even some progress were made toward adopting them, it could have a profound influence on our legal culture. So simply by announcing them, formulating them, advancing them, beginning to develop support for them, developing a movement, trying to push for them, you can begin to make a difference. Then we have some examples of cognitive dissonance on constitutional issues. The big one is the necessary and proper clause. And that goes back to the case of McCullough v. Maryland in 1819. Justice John Marshall writing for the court. That was a tax case in which the state of Maryland tried to tax the National Bank, which was headquartered in Washington, D.C. Now, they tried to tax it at a discriminatory rate that would make it difficult or impossible for it to do business in Maryland. So the first problem was that they weren't trying to tax it at the same rate they would tax the Maryland Bank. But that's not the way the argument went in the case. And it became a matter of just trying to decide whether Congress had the authority to charter a bank in the District of Columbia. And if they did, whether everything it did, all of its business, was exempt from taxation because the bank was an instrumentality of the federal government. The way the case should have been decided was that the operations of that bank, the First National Bank, should have been separated into its handling of government funds, which it was doing and which is properly exempt, from its commercial operations, which are properly taxable. But if it was taxed, it would need to be at the same rate and on the same terms that would be applied to any Maryland bank. That's not the way it came out, but in the course of making the decision, Justice Marshall wrote an opinion which reinterpreted the necessary and proper clause, which reads, as you may recall, powers necessary and proper for carrying into execution the foregoing powers. These were supposed to be incidental powers, powers just necessary for carrying into execution, not for exercising some new kind of power. In other words, they were intended for administrative things, hiring staff, renting office space, printing forms, putting out notices, basic stuff like that, and not to do whatever it might be thought convenient. In fact, Marshall said that, well, in popular usage, necessary sometimes just meant convenient. Well, the Constitution was not written in ordinary street English. It was written in legal English. And it was his duty as a justice to recognize the English in which the Constitution was actually written, and not the one that was used by ordinary people on the streets of the nation. Not closely related one in practice is the Commerce Clause. Originally, commerce only meant tangible commodities and the trade in them. But you could say the transfer of title and possession to tangible commodities for a valuable consideration to someone in a state from someone outside of that state. It's interstate commerce. But through a series of court decisions, courts began to recognize commerce as including not just tangible commodities, but services and mineral extraction and manufactured goods and all kinds of other things. And that's simply not what the word commerce meant originally. But it does illustrate a problem. We've introduced this subject as about cognitive dissonance. But the fact is that by the time that people started deviating from that original understanding, they had forgotten the original meanings of the words. So they were no longer dealing with the language in which the Constitution was written. Now, did they understand it at the time the Constitution was written? Yes, for the most part. But because they wanted to have the federal government exercise the power, because they felt constrained to let them do it, then they adjusted their thinking, their understanding, even their perception, their use of language to conform to what it is that they wanted to do or did do. And that, I think, qualifies as an instance of cognitive dissonance at play. The next thing that's been big is the non-delegation clause. In Article 1, Section 1, Clause 1 of the Constitution, it states that all legislative powers are vested in the Congress. Now that means that legislative powers may not be delegated to other branches, not to the executive branch and not to the judicial branch. In particular, they may not be delegated to administrative agencies. And yet, over a period of time, especially during the middle of the 20th century, these administrative agencies began issuing regulations which were allegedly authorized by congressional statutes, but which went into a lot more detail, added a lot of content, and they began applying them to private parties as well as to government employees or contractors. Now, of course, it was always understood that an agency could issue regulations for its own personnel, for its own employees and contractors, but applying them to ordinary people, especially prosecuting them criminally under regulations, for violations of regulations rather than for violations of a statute, was a very long step forward. And that's where we find ourselves today. But it was so easy to yield to demands to let agencies issue what amount to laws that after they started doing it and people started yielding to it, it became easier to say that, well, they're simply doing what the Constitution meant all along. And obviously that's not true, as anyone who is competent linguist or legal historian would recognize. Another is in the area of direct and indirect taxes. The term was used in the Constitution, but not defined there. And when the first court case came up, the Pollock case, the justices of the Supreme Court didn't know what it meant, and they got it wrong. Now, there was documentation that they could have referred to, namely the writing of Adam Smith, the great economist, in 1776, and his no use of the term was undoubtedly known to the founders, but they didn't document that they read Adam Smith. So the court says, well, we can't use what Adam Smith wrote because we don't have any evidence that the framers or the founders had read Adam Smith. In fact, they had, but they just didn't have evidence of it. So they went off and adopted a different meaning for direct and indirect taxes that we struggle with to this day. And because they once got it wrong, they've been getting it wrong ever since because it's easier to conform to the error than to correct it. Another one is the General Welfare Clause. The General Welfare Clause clearly, grammatically, is a restriction on the power to tax and by implication to spend. It is not the delegation of a power itself. And yet, after some struggling, the Supreme Court did finally yield on this and recognize the General Welfare Clause as the delegation of a new power. And we've been burdened with that ever since. And of course, so lawyers, judges have gone along with it and come to think of it as right. Another one is interpretation of regulation as prohibition, or that allows prohibition. The original meaning of regulation did not include prohibition. It could be said to be prohibition of certain modalities of something, but not all modalities. There always had to be some form of a thing that would be permitted for it to be called regulated. And by considering the power to regulate as a power to prohibit, the next step to that was to presume incorrectly that the power to prohibit meant the power to impose criminal penalties. And that is also not correct. Another major area of departure was to make notes, in other words, paper, legal tender on state territory. That was done as a result of the Civil War. The federal government issued scrip in other words paper money, greenbacks, to try to pay its debt to vendors, and they wouldn't accept it. They wanted gold or silver. Well, they sued and lost. So they had to then accept paper money instead of gold or silver. But then they were stuck with the greenbacks because nobody else would accept them. So another case went to the Supreme Court that essentially held that if the vendors had to accept greenbacks, then so did all of their vendors and everybody else in the country. So that led to the Illegal Tender Acts, which, although they don't actually say that they apply to the states, they could be interpreted reasonably to apply only to federal territories, the District of Columbia. In fact, it's been taken ever since that they apply to the entire country, including all the states. The next one is limited times. This is concerned with copyright and patent protection. The Constitution provides for creating limited monopolies for patents, inventions, discoveries, works of art for limited times, but it doesn't define what limited times means. Now, at the time that it was written, it was presumed to mean only for long enough for the inventor or discoverer to make a profit, and no longer. It was not intended that it should become some kind of estate which could be inherited by one's heirs or sold to, other people or persist for decades or even centuries. The authorization of force instead of a declaration of war or letters of marque and reprisal is a big one lately. We have a request for an authorization to use force recently submitted and then withdrawn from Congress. But the Constitution doesn't say anything about authorization of force, at least not in those terms. It says declaration of war or letters of marque and reprisal. Now, certainly those are authorizations to use force, but they have certain other elements with which an authorization of military force does not contain. A proper declaration or letters of marque and reprisal have to define an enemy. They can't leave the definition of enemies to the president. And they have to distinguish between who is an enemy and who is not an enemy. They also generally need to state a cause, either cause of war, casus belli, or a treaty obligation, casus feteris. They need to cite the offense that is a basis for it, and they should probably give a commencement date and terms under which the state of war or the letters of marque and reprisal can be terminated. Letters of marque and reprisal are generally proportionate. The idea was if a foreign country or its agents sank one of your ships, you could sink one of theirs, but not two of their ships, and so forth. Conscription. Well, the famous draft cases established when courts decided that people could be conscripted into the army under the alleged authority that raising an army was included as a necessary and proper power conscription. It is not. Raising an army only meant hiring military personnel for fixed periods of time. It did not include conscription. Then the deprecation of militia, first by creating a National Guard and calling it a militia when it's not, and second of all by declaring that everyone else is an unorganized militia without doing anything to organize them is a clear violation of the intent of the founders, and there have been further deprecation treating the term militia as though it's only a group of armed people, when in fact it is everybody in their capacity as defenders of the country. Another area of departure were habeas corpus and other writs, like quo warranto. The original concept of habeas corpus was issued by the crown, in other words, the king or his representatives, and one would petition the court to get the crown to issue the writ. However, when we went from a monarchy to a republic, the people became the sovereign. And at that point, you don't apply to the people for a writ. The people issue a writ, and then it is up to the respondent to either prove his authority or not. We made a serious bad turn there in continuing the process for getting writs of habeas corpus from a monarchical system to a republican system without adjusting it to a republican system. Then we have the problem of official and sovereign immunity. Sovereign immunity is the doctrine that a state may not be sued without its consent. Well, that's not quite, that's an overreach for doing what is illegitimate protection of the state from having all of its assets seized. The proper position would be to allow states to be seized to be sued with or without their consent, but to put constraints on the execution of judgments on money or property. So they could require a state to only pay judgments out of a fund that was established, appropriated by the legislature. They took a wrong turn there, but official immunity is another problem in that the court precedent was established that if a federal agent is doing his job, that he is immune from suit or from prosecution, criminal or civil. The problem is that just simply doing his job is too broad a concept. What is needed there is to make a more subtle and precise determination of what he is doing, whether he is acting within his authority from one moment to the next and in one way or another. So the purpose of a lawsuit over the exercise of authority is supposed to be able to sort all that out and not simply prevent him from being sued at all. So it should always be possible to sue an official. You might not get a judgment if it is decided that he was in fact acting within his legitimate lawful authority. But that is a fact and legal question that needs to be decided probably by a jury, since judges can't really be trusted to make that kind of decision. Now, there's also a problem with bills of attainder. I wrote a law review article on that subject, in which I pointed out that making it a federal crime to have been convicted of a state crime that has a penalty of 1 year or more, making it illegal for that person to own or possess a firearm, is a unconstitutional bill of attainder, because the state conviction probably did not disable the right to keep and bear arms, and even if it had, the only entity authorized to enforce that sentencing order would be the state, not the federal government. The federal government in that case, Congress, is trying to define certain classes of people as too dangerous to have weapons. And it's using various indicators of that: conviction of a crime, incarceration in a mental institution, abuse of alcohol, and any number of other conditions. Well, I think we can probably argue that such people probably are more dangerous than others, but that doesn't mean that the federal government has the authority under the Constitution to make it a crime. Jury trials are another problem. The Constitution provides that all criminal trials are to be decided by a jury. They don't mean just federal trials, they mean all trials, federal, state, and local. But the courts have held that that clause doesn't mean what it says it means, that if somebody pleads guilty or waives a jury, that's acceptable, that he has a right to waive a jury, and that it doesn't apply to the states. Well, that's not what the framers meant when they wrote that. They really did mean all criminal trials, whether the defendant pleads guilty or not, because you never know what the factors were that involved in getting him to plead guilty. The jury still needs to review the entire process, both the legal and fact issues, and decide independently. They might decide, even though he pled guilty, that he's not guilty. That's not for him to decide. That's up to the jury to decide. And finally, the notion that a treaty can confer new powers on Congress, that somehow the President and the Senate agreeing to a treaty with a foreign nation can give powers to Congress that it doesn't have under the Constitution. That's currently being litigated, and I think we can hopefully will get a decision that no such power can be acquired simply by entering into a treaty. But we'll have to wait and see what the decision on that will be. Now, I provided a long list here of areas of departure from strict compliance with the Constitution, and I could go much further. But if you examine each one, you can see the play of cognitive dissonance at work here. In each case, there are now people, judges, lawyers, other officials, members of Congress, who will proclaim on a stack of Bibles that all of what they're doing is constitutional, that they're not violating the Constitution, that it's not a violation of the 10th Amendment, that they do have authority to do all these things. And they really believe it. It's not that they're lying. It's not just that they're ignorant or incompetent, although they are those things. It is that they have really persuaded themselves that what they're doing is constitutional. And that we, in our efforts to get government, and Congress in particular, and the courts, to comply with the Constitution, have to overcome not just error, but entrenched error, self-delusional error. So we have our work cut out for us, and that provides a path forward for our efforts in the future.